A very engaged quorum being present, the Committee on Education Workforce will come to order. Hate to stop all these fun conversations, but good morning. Before I recognize myself for an opening statement, I want to take a moment to recognize and welcome the newest member of the committee, Congressman Jim Banks. Congressman Banks represents the 3rd District of Indiana, and he has been very enthusiastic about joining all of us here at the Education Workforce. Congressman Banks, we're happy to have you, and I know we all look forward to working with you.
The gentlelady yield.
I will.
Thank you. I'd like to join in our welcome for Mr. Banks and look forward to working with him on the committee. He'll find that there are a lot of issues that will be very important to his district, so I look forward to working with you on those issues.
Thank you, Mr. Scott. With unanimous consent, I submit for the record an updated list of subcommittee members for the majority to reflect Representative Banks' assignment to the Subcommittee on Higher Education Workforce Development and the Subcommittee on Health, Employment, Labor, and Pensions. Hearing no objections, the subcommittee assignments are made. I now recognize myself for opening remarks. Welcome to today's hearing. I want to thank our witnesses who have taken time away from their schools and other important jobs to offer their expertise on student privacy and ensuring that student data is being used properly. I also thank our members for being here and want to recognize their continued interest in this subject. Over the past several decades, there's been a significant leap in the ways that technology can be used to strengthen classroom instruction and improve student outcomes. Companies specializing in education technology have provided teachers, school districts, and states with the cutting-edge software and tools needed to create a modern learning environment that inspires student success. The use of this technology can greatly enrich the student experience and help teachers adjust instruction according to the needs of their students. However, questions of privacy will always accompany any discussion of student data collection, as well they should. Concerns have been raised that information such as attendance records, school performance, and other aspects of students' personally identifiable information may be shared, sold, or mined by the companies that collect it. In an effort to provide parents with confidence and peace of mind, several companies have signed a student privacy pledge that holds service providers accountable to a list of stipulations, including not selling student information, providing comprehensive security, and being transparent about the collection and use of data. While this commitment from the technology community is encouraging, it is only half of the equation. More must be done to ensure that student data remains confidential, and updating the Family Educational Rights and Privacy Act, FERPA, is a crucial step to ensure better protections. This law is intended to protect student privacy and stipulates who may access student education records and the ways those records may be shared, both with and without parental consent. More than 40 years have passed since FERPA's enactment in 1974. In those decades, which have seen breathtaking innovation and technological advances, FERPA has been amended just a couple of times to address changing circumstances under which a student's personally identifiable information may be released. Times have changed and the law is in need of a more substantial reform to better reflect the current realities of data collection in schools and classrooms. We need to clarify what data is a part of the record. We need to ensure access to the information is limited to those who truly need access to the data, and we need to ensure that anyone who accesses that information is known and knows the rules of using that data. In January, this committee held a hearing on evidence-based education policymaking and the importance of strengthening education research while protecting student privacy. Today, we're focused on what schools and states actually do to protect that data through limiting what is collected and providing better security over the data that is collected. Given their unique areas of expertise, I'm looking forward to hearing our witnesses give members an on-the-ground look into what states and educators are doing to keep students' personally identifiable information safe. I look forward to the discussion today as this committee works to ensure the continued protection of student privacy. With that, I recognize Ranking Member Scott for his opening statement.
Thank you, Madam Chair, and I want to begin my remarks by recognizing the importance of student data privacy. Privacy is an important civil rights issue and is a ripe area for bipartisan cooperation and is worthy of the committee's time and attention. That said, I must note that today, May 17th, is the 64th anniversary of the Supreme Court's unanimous landmark ruling in Brown v. Board of Education. 64 years ago, our nation's highest court declared separate to be inherently unequal and ordered public education to desegregate in order to provide equitable learning opportunities for all students. Unfortunately, since taking office, the Trump administration has relentlessly chipped away at civil rights protections, including civil rights protections in education. In its first year, the administration rescinded one Obama-era civil rights guidance that protected rights of transgender students and rescinded another that pushed colleges to meet their legal obligations under Title IX in addressing campus sexual assault. This year, Secretary DeVos has taken steps to erode protections for students of color with disabilities by proposing a delay in the equity in IDEA rule, a delay overwhelmingly opposed by students, parents, teachers, civil rights advocates, and individuals with disabilities. This important rule is set to go into effect this July and clarifies when school districts must take action to address disparities in identification, placement, and discipline of students of color with disabilities. Most recently, Secretary DeVos directed the Department's Office of Civil Rights to stop investigating cases of systemic inequities that harm minority students and even reopened previously resolved cases concerning accessibility for students with disabilities. Next Tuesday, members of the committee will have the first opportunity to question Secretary DeVos nearly a year and a half into her tenure. Such a delay of oversight of the Secretary of Education is unprecedented in recent history. The importance of meaningful oversight is growing. Secretary DeVos is publicly signaling her intent to rescind the 2014 Education, Justice, School Discipline Guidance Package promulgated under the Obama administration. That guidance outlines how school districts can avoid racial disparities in discipline, especially suspensions, without jeopardizing school safety. Rescinding that guidance would be particularly troubling in light of a recent report by the nonpartisan Government Accountability Office that found black students accounted for 15% of public school students, but represented 39% of students suspended from school. Findings also show that discipline disparities aren't merely a function of minority students acting out more, as is often the claim. The role of racial bias in perpetuating educational inequity, whether explicit or implicit, cannot be ignored. Many observers believe that the administration's attack on the 2014 discipline guidance is a first step in a full-scale assault on the disparate impact doctrine, which will deprive us of a fundamental tool for investigating violations of civil rights laws. Later today, I'll be joined by the Judiciary Committee Ranking Member Jerry Nadler, a Democratic Caucus leader, and Tri-Caucus leadership in introducing a resolution to express the sense of Congress that disparate impact remains a fundamental enforcement mechanism under Title VI of the Civil Rights Act. I encourage all members of the committee to join this resolution and articulate their support for advancing educational equity. It is our job as the Committee on Education and the Workforce to ensure the Department of Education is implementing and enforcing federal laws, including civil rights laws. There's an appropriate time to challenge student data privacy as a standalone issue, but while we do this, we should also take the time to honor both the legacy of Linda Brown and the cause of millions of students, parents, teachers, and civil rights leaders across the country who continue her fight for a system of public education that lives up to our ideals of equity and fairness. Well, I welcome all of today's witnesses. I'm especially grateful for Catherine Lehman, the former Assistant Secretary for Civil Rights at the Department of Education under the Obama administration, for accepting our invitation to help broaden the focus of this hearing. Thank you, Madam Chair, and I yield back the balance of my time.
Thank you very much, Mr. Scott. I would tell you, yesterday I spoke on the floor to commemorate the Brown versus Board of Education ruling by the Supreme Court and to honor the legacy of Linda Brown. Pursuant to Committee Rule 7C, all members will be permitted to submit written statements to be included in the permanent hearing record. And without objection, the hearing record will remain open for 14 days to allow such statements and other extraneous material referenced during the hearing to be submitted for the official hearing record. I will now turn to introductions of our distinguished witness, and I recognize Mr. Guthrie to introduce our first witness.
Thank you very much. I want to introduce my fellow Kentuckian, Mr. David Couch, who's here with us today. I remember when David came back to Kentucky after going to West Point, serving at West Point, and going through the military and coming back in his leadership. I was in the state Senate when he came back to run our data within our Department of Education. He's now the CIO for K through 12 education. And the only thing that always bothered me, we missed each other at West Point. He was a little bit older, and people always asked me, were we there together? And so I didn't get to serve with him because I said, do we really like we were there together? Actually, we're pretty close in age. I missed him by a year. But while I have, if I could just take about 15 seconds while I'm here, I had the great privilege, and since David didn't get to harass me while I was there, my squad leader during our basic training was the very low-key HR McMaster. So we did go through, but I only say that to say this. Tomorrow, HR McMaster is retiring, and so we're about to lose one of the greatest soldiers of our generation. So I just want to comment, tomorrow afternoon he will be retired. So thank you very much for having me here, and thank Mr. Couch for coming. Thank you.
Thank you very much, Mr. Guthrie. I will introduce the remaining witnesses. Ms. Amelia Vance is Director of Education, Privacy, and Policy Council with the Future of Privacy Forum here in Washington, D.C. Ms. Catherine Lehman is an attorney and a former Assistant Secretary for Civil Rights at the U.S. Department of Education in the previous administration. Dr. Gary Lilly is the Superintendent for the Bristol, Tennessee City Schools in Bristol, Tennessee, a very close neighbor. I now ask our witnesses to raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Let the record reflect our witnesses answered in the affirmative. Before I recognize you to provide your testimony, let me briefly remind you of our lighting system. We allow 5 minutes for a witness to present testimony. When you begin, the light in front of you will turn green. When 1 minute is left, the light will turn yellow. At the 5-minute mark, the light will turn red. At that point, I ask that you wrap up your testimony. Members will each have 5 minutes to ask questions of the witnesses. Mr. Couch, you're recognized for 5 minutes.
Thank you. On behalf of the students and educators in the Kentucky Department of Education, thank you for this opportunity to testify today on the topic of cybersecurity and privacy from a statewide K-12 perspective. We firmly believe protecting student data is crucial, and everyone from the classroom all the way up to the State Department of Education level has a meaningful role and responsibility in cybersecurity and data privacy. While we do many things from a pure technology perspective to provide cybersecurity at the state and district level, we spend more time on professional development, or what we call the people side of cybersecurity and privacy in Kentucky. There were over 4 billion attempted attacks of Kentucky K-12 services this past school year. However, our biggest vulnerability is by far internal staff, not external criminals. We very early realized that we can't expect our educators to be cybersecurity specialists. However, everyone has a role to play in maintaining security. We also believe our Kentucky K-12 students and teachers can be innovative while at the same time respecting the importance of cybersecurity and privacy. Lastly, we believe and support that some of the laws, FERPA, around data security and privacy need to be updated and modernized to recognize a technology-immersed environment in K-12. For the past 2 decades, I have been the Kentucky K-12 Chief Information Officer. I'm the longest-serving state-level CIO of K-12 in the United States. Before coming to KDE in the early 1990s, I was an Army officer in a senior leadership position in the Army's most modern intelligence electronic warfare facility at that time. So I can tell you with confidence that Kentucky K-12 has been the pioneer and national leader in most aspects of K-12 education technology from a statewide perspective. Therefore, we've had the internet, cybersecurity, large-scale data systems, instructional technology, and electronic communications on our radar screen much longer than anyone else. I find through CCSSO's state CIO network, most of my K-12 state-level peers in other states don't look at each other as competitors, but instead try to help each other in all aspects of education technology, including cybersecurity and privacy. In the 1990s, Kentucky K-12 became the first state to provide high-speed internet access to every district, the first state to provide a common statewide financial management system, student information system, and email system for every district. In the 2000s, the first state to connect every district office and school by fiber, as well as the first state to meet the national goals for internet speed per student. Beginning in 2009, became the national leader in cloud-based computing. In 2011, created the nation's first digital driver's license for our K-12 students and adults to help them be good digital citizens. In 2014, implemented a robust statewide internet safety and content management service for all 173 districts. In 2015, created a comprehensive cybersecurity best practice guide based upon reviewing and including some of the best practices of the other 49 states. In 2016, created a one-pager for K-12 teachers to help them better understand data breaches and how to prevent them. Every district, no later than each August, must provide an annual cybersecurity health check to their superintendent and their local board. Every district superintendent submits annual assurances related to the 9 elements of digital citizenship and cybersecurity. Additionally, we require our statewide EdTech vendors to agree with a signature that they are aware of and abide by Kentucky's data breach notification and student privacy laws. We have put the Department of Education on a healthy data diet, so we collect only the data that we know is necessary. We regularly encourage our districts to do the same. A healthy data diet also means only seeing the data you really need to see. In the military, we call that need to know. We don't want to provide extra permissions to people who don't need them. The greatest number of data breaches in Kentucky K-12 by far are either accidents, such as posting PII on a website or sharing a spreadsheet with hidden columns of Social Security numbers, or from the lack of savviness of staff who fell for a phishing scam like, your mailbox is over its limit, please hand over your password. Professional development and awareness are the solutions for this issue. While Kentucky has invested a great deal of time and resources into securing our environment, there are still some improvements we'd like to see at the federal level. Update FERPA to include vendors along with districts and schools. Add meaningful penalties and fines to FERPA for an organization that receives data and subsequently exposes the data, and require more succinct and to the point human speak terms of service from all vendors. Thank you.
Thank you very much, Mr. Couch. Ms. Vance, you are recognized for 5 minutes.
On behalf of the Future of Privacy Forum, thank you for inviting me to testify today. My name is Amelia Vance, and I am FPF's Director of Education Privacy. FPF commends Chairwoman Fox, Ranking Member Scott, and the committee for holding this hearing. FPF is a nonprofit organization focused on consumer privacy issues. Our Education Privacy Project works to ensure student privacy while supporting technology use and innovation that can help students succeed. In 2014, FPF and the Software and Information Industry Association founded the Student Privacy Pledge. The pledge, which now has almost 350 companies as signatories, is a voluntary code of conduct that is legally enforceable by the FTC and state attorneys general. We also run FERPA Sherpa, the Student Privacy Resource Center website. Education has changed dramatically over the past 2 decades. In FPF's 2016 survey, 90% of parents said their children were using school-provided technology. Numerous surveys indicate overwhelming parental support for the proposition that EdTech can and has improved how their child learns. However, a majority of parents in our survey also expressed that they had security, privacy, and equity concerns. Trust is therefore key for the adoption of innovative technology in education. In response to parental and privacy advocate concerns, there has been a monumental shift in the state legal landscape. Since 2013, 39 states have passed 119 bills specifically focused on student privacy. For the first time, many of these laws directly regulated edtech companies. However, few state laws have addressed one of the most frequent ways that student data is inappropriately disclosed. Both in schools and at companies, human error is a leading cause of security breaches and privacy violations. The focus of my testimony today will be on how companies are helping districts safeguard data and manage the complex legal landscape. Sometimes companies build trust through self-regulation and best practices. Many companies partner with my organization and SIA to create the Student Privacy Pledge. Its commitments are clear and concise promises regarding how edtech companies will use, share, and protect student data, and encourage them to more clearly articulate these practices. Leading companies have partnered with schools or states directly as well. For example, the Student Data Privacy Consortium, founded by Cambridge Public Schools in Massachusetts and now present in 17 states, has had over 600 companies sign just the California Student Data Privacy Agreement. Other companies, even those not specifically serving the education space, have partnered with districts to adapt those products for the classroom. We have also seen companies use this privacy landscape as an opportunity to innovate and partner with schools to fulfill their privacy obligations. For example, by providing dashboards where teachers and parents can see which apps have gone through a privacy review, or by helping districts figure out all the edtech tools that are being used. If you would like more information, I've included specific examples in my written testimony. Despite these encouraging actions, there are still many challenges, but also opportunities. As I mentioned, FPF reviews the relevant policies of each new company that applies to join the Student Privacy Pledge. Unfortunately, we often see cookie-cutter contractual terms that are inappropriate for the student data space being incorporated into privacy policies, usually because the company is unaware of the unique legal requirements and best practices for operating in education. Schools need to be able to quickly and easily evaluate a product's privacy policy. There is an opportunity here for more companies to step up and provide clearer and more targeted information. With the influx of new state laws and local policies layered onto existing federal laws, many companies are still struggling to understand and fulfill their privacy obligations. Schools, states, and companies must live up to the trust placed in them by their communities, but they should not have to hire a student privacy expert to understand how to do so. While the U.S. Department of Education's Privacy Technical Assistance Center has provided incredible guidance and resources, more guidance and funding is needed to help reach all stakeholders. Actions like holding this hearing helps elevate student privacy in the mind of every school leader and EdTech CEO, and I hope these conversations continue. Thank you.
Thank you, Ms. Vance. Ms. Lehman, you're recognized for 5 minutes.
Chair Fox, Ranking Member Scott, members of this committee, thank you for inviting me to testify today. I am Catherine Lehman, and I chair the U.S. Commission on Civil Rights, and I'm of counsel at the National Center for Youth Law. Before holding those current positions, I was Assistant Secretary for Civil Rights at the U.S. Department of Education. I speak to you today in my personal capacity and not on behalf of the U.S. Commission on Civil Rights or on behalf of the National Center for Youth Law. Today, on the 64th anniversary of the United States Supreme Court's path-breaking decision in Brown versus Board of Education, I appreciate this committee's invitation to speak to the pressing civil rights topics threatening our nation's commitment to equity in education. And I share here a handful of examples of the ways that the U.S. Department on Education today creates an equity emergency while ignoring Congress' express instructions and decisions of federal courts. In this administration, the Department of Education repeatedly undermines equity, contrary to its congressional charge. Just this week, news reports confirmed that the department has effectively ceased the important work of making defrauded for-profit college students whole and of operating effective controls against financial fraud for vulnerable students, running directly counter to the equity mission of the department. In addition, rather than driving forward with urgent response to persistent data reflecting that students of color with disabilities are subject to exclusionary school discipline at rates wildly disproportionate to their student population numbers, this administration seeks a 2-year regulatory delay to contemplate further a problem Congress 14 years ago charged the department to address. In a similar vein, this administration has created a commission headed by the Secretary of Education, charged specifically with making recommendations on the repeal of existing policies regarding non-discrimination in school discipline. That announcement alone signals that compliance with non-discrimination laws in this area is now optional. It is deeply dangerous to equity to send a message that satisfaction of the nation's core civil rights principle, prohibiting discrimination against Americans on the basis of race, is merely an aspiration and not a mandate. Notwithstanding the demonstrated importance over decades of federal civil rights enforcement, every time this administration has had an opportunity to express its values through budgets, it has chosen to undervalue equity, requesting devastating reductions to the Department of Education's budget generally and to the budget of the Office for Civil Rights specifically, drowning the possibility of meaningful civil rights enforcement. In this administration, the Department of Education has so far unchecked arrogated to itself the power and authority to ignore the law. The department has made a blanket determination that federal law prohibiting sex discrimination in schools does not protect transgender students' right to access bathrooms and locker rooms consistent with their gender identity, taking that position even in those states that are bound by federal court decisions that reach exactly the opposite conclusion. Congress has not and constitutionally could not have given a federal agency authority to ignore the law. The department's flouting of the law that binds it has wide-ranging ramifications for each and every civil right Congress has charged the department to protect, and therefore for every student who relies on the department for equal educational opportunity. Those wide-ranging ramifications are not theoretical. OCR has newly begun placing an arbitrary limit on justice, closing and refusing to open cases over which it has jurisdiction, simply because a complainant who seeks aid from OCR has filed some unspecified number of other cases in addition. OCR lacks jurisdiction to pick and choose which cases to open. Its regulatory charge is to act, quote, whenever it has evidence that the law it enforces may have been broken. That charge means that OCR must open for investigation any timely complaint over which it has jurisdiction. But OCR's new practice actually turns the federal government's back on evidence of discriminatory harm to students. At a time when the best available evidence shows ample need for strong enforcement, the Office for Civil Rights is relinquishing its rightful place on the field to protect the right that gave it its name. In this administration, the Department of Education's Office for Civil Rights has abdicated its commitment to enforcing all the laws within its jurisdiction fairly and fully. For example, the department has begun renegotiating existing agreements with schools regarding how to protect the rights of students with disabilities, undermining these students' rights as distinct from protecting them equally with all other students. This devaluation of existing resolutions of viable civil rights cases signals in the strongest possible terms that the department is not reliably open for business for students with disabilities. Similarly, the department recently rescinded existing guidance regarding schools' obligation to prevent and respond to sexual violence, replacing it with new guidance that violates Congress' mandate prohibiting sex discrimination in schools. I see that my time is close up. I will close by saying that the strongest indicators so far during the first 16 months of the current administration suggest inattention to and often direct contravention of core civil rights commands Congress has over decades directed to the Department of Education. The nation's students deserve congressional vigilance to correct those practices with, as Dr. King put it, the fierce urgency of now. Thank you.
Dr. Lilly, you're recognized for 5 minutes.
Good morning. I am honored to be here to address student data protection and privacy. School systems educate a very popular demographic. From businesses to youth rec leagues, it sometimes seems like everyone wants access to our students. What keeps me awake at night is knowing that there are bad actors around the world who are actively working to find, compromise, and sell student data that should be kept private. And schools typically collect a lot of data about students. To register a student, we need his or her basic demographic information, such as their name, address, phone number, gender, and race. But we also have to be able to differentiate one John Smith from another John Smith, either within our own district or from the district down the road. That means either collecting their social security number or assigning some other unique identifier. We ask for their parents' information, emergency contacts, and any medical conditions they may have. And all of that is just to get them enrolled. Over the course of their K-12 educational career, we amass even more data. We store the classes they take, the grades they make, their attendance, standardized test scores, if they're eligible for free or reduced lunch, any disabilities they may have, and we log their behavior. My district keeps all this information in an online database, which is stored on a secured server behind 2 firewalls. Even so, the state I'm from, Tennessee, requires districts to sync information to their statewide system daily. Hopefully you're seeing that student data is accessible to many people on various systems legitimately. Like most districts, we are taking steps to protect that data to the extent that we can. We check and vet all of our employees before hiring them and also restrict the type of data they can access based upon their role. We have quarterly meetings to discuss student and employee data and privacy protections. The problem is that it's difficult to think like a criminal if you're not one. So we use a service called Bright Bytes Digital Privacy, Safety, and Security that leads administrators through a questionnaire and offers support and documentation that helps us think about changes we should consider to our policies, professional development programs, systems and infrastructure, and incident response. We also use a managed internet service provider, Educational Networks of America, which uses traffic pattern analysis and other methods to identify attacks and mitigate their impact. We do work with a number of educational service providers that also store student data. We're currently working on verbiage for contracts with outside vendors to ensure there are safeguards for data stored off-site. We want to know, how are they using that data? Where is it stored? To whom is it disclosed? And when we no longer have a contract, how will it be disposed? Internally, we continually attempt to educate both employees and students about the importance of protecting their data and digital citizenship. Earlier this year, we actually hired a firm to run a phishing test on our employees so we could better target individual opportunities for development. Because we talk about it all the time, I was sure that we wouldn't have many, if any, fall for a phishing attempt. I was shocked when the results suggested that almost 20% of our folks were fish prone. And even that is supposedly a good bit lower than the industry average. It was definitely eye-opening and a good reminder that we have to stay vigilant. I appreciate that you all want to assist with the work we are doing to protect our students. Title 4A and ESSA allows districts the flexibility to do what we need to do to assess and harden data systems. It is also imperative that we have support to educate both students and employees about how to safeguard data and privacy. The Family Educational Rights and Privacy Act also needs to be regularly reviewed and updated to keep up with the pace of technology. Ideally, the federal policy will align with and complement state and local efforts. I encourage you to see what works, what doesn't, and explore any unintended consequences that might create impediments for districts. I further encourage you to begin by clearly defining what is considered an education record, including digital files. Currently, there is considerable confusion regarding what must, may, or may not be disclosed. For the first time ever, our district purchased a cyber protection insurance policy this year. It's my sincere hope and prayer that we never have a need for it. Any help you can provide to make the policy unnecessary will be greatly appreciated. Thank you.
Thank you very much, Dr. Lilly. I'll begin with the questioning. You all testified about what you do to protect privacy, but I want to ask you to summarize in one question why privacy matters, especially when it comes to student information. Mr. Couch.
Well, I think there's a level of trust that we've been given. Always a reminder that the parents and the students own the data, and we are just the stewards of that and try to be good stewards of it. And the potential harmful things that can be done in the long term for the student. For example, if you get a student Social Security number when they're 12, well, that could be used by someone in a very destructive way for 4 or 5 years before the student realizes it's been done. And so there's a very serious part to it that we try to stay focused on.
Ms. Vance?
Without privacy, I would say it undermines the potential of technology in the classroom and data-driven decision-making because of a lack of trust.
Okay. Ms. Lehman?
Effective data is critical in moving forward with equity in schools, and making sure that student privacy is fully protected is critical to that effort as well.
Dr. Lilly?
Quite simply, we owe it to our students. Students, we are collecting information from them, and so it is our duty to protect that information.
Thank you very much. Mr. Couch, you specifically mentioned the need to have vendors sign an acknowledgement that they will abide by the state's notification for breaches in privacy laws. So please tell us why it's important to that acknowledgement is signed.
Well, I think just like in our private lives, we take things a lot more serious when we sign it and put our signature on it than versus someone doing a head nod. And so for the most part, we found our vendor partners have been very willing to do this. It's not something that we had to press hard, but a signature just puts an extra stamp of, I'm committed.
Thank you. To Dr. Lilly and Mr. Couch, each of you shared why privacy matters, but could you tell us what your biggest challenge is when you try to tackle this issue? You've alluded to it in some of the comments you made, and tell us how you address it, and if you think that there's something your colleagues could use to help in their schools facing similar issues. Dr. Lilly?
So there are different legs to the stool when it comes to protecting student data and privacy. Infrastructure is one piece of it. School districts need to make sure that they have infrastructure in place to protect it. Education cannot be overstated. We have to educate the folks or employees who are working with that data, but also students in protecting their own data, and also policy. So in our school system, we have a policy that defines student records and who may access and those things. So that's kind of a three-legged stool that we have to meet all of those challenges.
Mr. Couch?
And I would be very supportive of what he said, and I won't repeat it. The part I will add on to it is what we've done in Kentucky, and we encourage everyone to do, is go on a healthy data diet. And that's challenge yourself at least once a year. The data you're collected, you really, really have to have it. And more importantly, is this something that the districts see added value in for the local decision making? Because the quality of the data is the best if they use it locally and it's rolled up. And so if you're collecting a lot of things and they're saying, I'm giving it to the state or federal level, the quality is very low. But also, in the early 2000s, we went through a healthy data diet and removed 90% of the data we collected from school districts. Just because over the course of time, people have come and gone and the priority issues changed. So it's a healthy thing to do in your organization. It reduces the kind of area that these folks can attack it by not having it there at all.
I like that phrase. Thank you all very much. I yield back and recognize Mr. Scott.
Thank you, Madam Chair. Ms. Lehman, as you mentioned in your testimony, the Trump administration has been actively seeking to roll back protections for students with disabilities. On Monday, a comment period regarding a potential delay of the equity and idea regulation closed with most of the comments opposed to the delay. Of those opposing, 37 members of Congress, including some of our colleagues here, suggested that rolling back the regulations was actually a violation of the congressional intent. One of the claims by the organizations supporting the delay is that the Department of Education does not have the authority to regulate on an issue of significant disproportionality. Is that accurate?
It categorically is not. I can expand on that if you like, but I can leave.
Please, if you could.
The Individuals with Disabilities Education Act amendments explicitly give the department authority to give effect to that law. As well, the department, of course, has authority to regulate about the areas within its jurisdiction. So the department is required to enforce the law and has, for more than a decade, recognized that the significant disproportionality language that is in IDEA from Congress has not been given effect in states around the country and in school districts around the country, and so it was time for the department to act.
Thank you. And why is it important and effective to address systemic discrimination as opposed to one case at a time?
Well, the department's obligation is to ensure that no student is subject to discrimination under any of the laws that the department is authorized to enforce. And the obligation to ensure that no student is subject to discrimination means that the department needs to be looking with a wide lens at what can happen in school. It's very unusual for a school to have particular animus against one child or one student that is different from the way that it treats the class of students who are like that student. So if the law is violated with respect to one student, it may well also be violated for other students as well, and it is the department's job to ensure that no student is subject to harm in school.
In an effort to address persistent educational inequities due to overuse of exclusionary discipline broadly, we have found through the GAO report that there is a significant disproportionality in exclusionary discipline policies. DOJ and Department of Justice and Education released the School Discipline Guidance Package in 2014. The letter explaining that suggested that requirements under Title IV and Title VI of the Civil Rights Act of '64 needed to be enforced and reminded the localities of their obligation to administer school discipline without discriminating. Can you say why the guidance was needed?
Mr. Scott, I was very proud to sign that guidance, and I believe with every fiber of my being that we need to make sure that all of our students are subject to equal treatment in school. What we have seen over the decades that the Office for Civil Rights has been in existence is that our schools consistently and persistently operate disproportionate school discipline with respect to race as well as with respect to disability in schools. And the need to correct that for the individual students who are subject to it is crucial, and the need to correct that for the message that it sends to all the students in schools about the value of students and their peers in schools is essential. That guidance does nothing more than to say what the law is and how to satisfy the law. It gives effect to what Congress has long promised to this nation, and it is critical to making sure that we stem the tide of discrimination that we have seen persist over far too many decades in our schools.
And the guidance letter did not place any new legal requirements on the school, just reminded them of what their legal obligation actually is?
That's exactly right.
Can you say how the guidance would affect school safety?
Well, the guidance affects school safety in that it protects students from discrimination, and that's core to school safety. It has absolutely no impact on schools' ability to protect their students from external safety threats or from the kinds of safety threats that can come up in schools. In fact, the guidance was explicit that schools must be able to protect their students from harm in school and to maintain effective classroom discipline.
Thank you, Madam Chair.
Thank you, Mr. Scott. Mr. Wilson, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. Dr. Lilly, I want to thank you for your testimony on this important issue. As the grateful husband of an educator, I know the great lengths that you take and sacrifices you make to properly educate our nation's youth. In your testimony, you mentioned concern not only about the amount of data that is collected, but also the accessibility by bad actors. You state that you use several services like Brightbits, Digital Privacy, Safety and Security, and Educational Networks of America, and also hire phishing firms that provide support, identify attacks, and offer recommendations for changes to protect student privacy. Could you elaborate about some of the recommendations you've received, whether they've been implemented and their effectiveness?
Yes, I'll be happy to. Through the Bright Bites work, it really helps us think about the policy changes that we need to make. Certainly, with the advent of digital records, things have changed. You know, at one point in time, a manila folder would follow a child through their schooling experience. That's no longer the case. So we have taken a look at hardening our infrastructure. We are doing a lot of professional development to try to make our employees aware, but also students aware that they've got to protect their own data and privacy. Each year we do what we call Internet Safety Blitz at the beginning of the year to try to educate our students. We do annually notify parents of the information that we collect, and they have the right to inspect and review that information at any time. I was surprised when the phishing firm that we hired returned that there were issues where people actually fell for those phishing attempts, because I was not expecting that to be the case, which tells me we have more work to do and we have to keep it out there in front of people all the time. It is very important.
Well, thank you for your positive attitude and your efforts. Ms. Vance, thank you for the testimony today on behalf of the Future of Privacy Forum. In your testimony, you state that since 2013, 39 states have passed 119 bills surrounding student privacy. You go on to detail several examples of how the laws of many states can create an administrative burden for compliance. What suggestions would you have that you would offer to prevent this burden while still ensuring that companies and schools are respecting the privacy rights of students?
Thank you. I think the primary thing that would help my colleagues at this table and many of the districts and states that I work with is, in general, more support for training. I didn't give the percentage in my testimony, but it's estimated anywhere between 45% and 95% of all data incidents or breaches occur because of human error, and that is the low-hanging fruit in order to address so many of the concerns that come from parents and others.
Thank you very much. And Mr. Couch, thank you for your testimony before the committee. I am grateful for your 20 years of service as the Chief Information Officer with the Kentucky Department of Education. As a father of 4 sons in military service, I appreciate your service as an Army officer working on these issues. As the former chairman of the Emerging Threats and Capabilities Subcommittee of the House Committee on Armed Services and the current chairman of the Readiness Subcommittee in the Armed Services Committee, I understand the vulnerabilities of our nation's cybersecurity network. You mentioned some pretty startling numbers when it comes to attempts to gain access to the information. Do you believe these numbers are likely similar for other states? How important is it that staff education about the dangers that are out there in helping to prevent any of these attempts from being successful?
You know, the 4 billion attempts that we received were kind of like they were checking the doorknobs or the windows to see if you were there. There was an 85% increase in phishing attacks over the past year, and starting in November. And some of those are spear phishing, where they're getting very sophisticated and know who to go after within a district, which makes it they're pretending to be the chief financial officer or the superintendent, and it looks like it is them. So I really think this is happening across the country. It's not unique to Kentucky, that is for sure. And just because it's an internal kind of failure doesn't mean it's just not as important. In fact, that's some of the most crucial data that we have out there. So that's why the risk, much like what Dr. Lilly was talking about, we put a lot of effort on trying to build capacity within districts so they can champion this as well about the importance.
Thank you. These numbers are startling. I appreciate Chairwoman Fox and Ranking Member Scott for bringing this to the attention of the American people.
Thank you, Mr. Wilson. Ms. Fudge, you're recognized for 5 minutes.
Thank you very much, Madam Chair, and thank you all so much for being here. I want to thank my colleagues for recognizing the 64th anniversary of Brown v. Board. Unfortunately, by recognition, we might make someone believe that we are going to enforce it. I guarantee you that we are not. We are right now find ourselves in a time where the Secretary of Education really wants to take us back to pre-Brown v. Board days. She is actively undermining public education funding, the equitable distribution of resources, and civil rights protections that by law she is required to uphold. The Secretary and this administration have taken steps to disproportionately harm public schools while increasing funding for private, parochial, and charter schools. It's just kind of like taking from the many and giving to the few. It's taking from poor people and giving it to the rich. That is where we find ourselves today as we continue to disinvest in public education. And if you take that with the purposeful underfunding of the 2020 census and putting questions that may, in fact, frighten people from filling out the census, so now the resources are going to be even smaller because they are not going to have an accurate count. So I would say that if it were up to the Secretary, poor, minority, disabled children would never be afforded a quality education. A quality education has become the civil rights issue of our time. With that, I would ask Ms. Lehman that your mission into civil rights is to ensure equal access to education. As you mentioned in your testimony, actions taken by OCR seem to suggest an abdication of these responsibilities. What are the legal requirements for OCR regarding enforcement of civil rights law?
Thank you. The requirements for the office are to enforce each of the federal civil rights laws that the Congress has given them jurisdiction over, and each of those laws guarantees that no student shall be subject to discrimination on, for example, the basis of race, sex, ability status. And the office is to share information with the American people, conduct aggressive enforcement to make sure that the rights are actually protected in schools, provide proactive technical assistance to help schools come into knowledge about how to satisfy the law, and where schools are declining to satisfy the law, actually to take this step, the ultimate step of withholding federal funds if the school will not agree to comply moving forward.
Thank you. If demographic data is skewed significantly because of an undercount in the census, how would this impact the disparate impact analysis and enforcement for federal civil rights and equity law?
Well, an undercount of whom our students are, who Americans are, who may have students attending schools will be devastating for our nation's schools, among other components of civil rights. They will receive less funding for the students. They will be less able to actually satisfy students' rights, much less give them educational opportunity. And in fact, the disparate impact analysis, among others, will be much harder to engage in and to follow through with, because that core count of whom we are and who we need to serve as government is crucial to every other aspect of our civil rights.
Thank you. You know, it's interesting to me that we would have a secretary from a party that always talks about we shouldn't pick winners and losers. We pick winners and losers when we decide to not fund fully public education where the majority of the children in this country go. We pick winners and losers when we decide that children should get a better education if they go to a charter school, a private school, or a parochial school. I think that we have not been good stewards of the resources for taxpayers by deciding who wins and who loses. Do you think that's fair?
I think that's absolutely fair, and that the notion that there are some children who are worth more than others is anathema to us as a country. It's contrary to all of our core democratic principles, and it is deeply, deeply offensive to the laws that the Department of Education is charged to enforce.
And if these other schools are so good, why don't they share that information with the other schools? If they know so much more and can teach children so much better, why would they withhold that information from the majority of the children? Why would they not make all children receive the same kind of education? You think that's fair?
I do think that's fair, Congresswoman. I'm a believer in transparency for all of us and being able to take best practices and apply them to all places where our children are in school.
Well, I thank you, and I thank you all for being here. But on this 64th anniversary of Brown v. Board, let us remind people that we have never lived up to that standard. I yield back.
Mr. Allen, you're recognized for 5 minutes.
Yeah, thank you, Chairwoman Fox, and thank you, witnesses, for participating in this hearing that I think we're talking about, basically cybersecurity. But anyway, as far as, at least that's what I'm here to talk about, and that's what the questions that I have to ask. In my district, we have the new Cyber Center of Excellence. And I have learned a lot about the threats with regard to cyberspace. Now, that's more related to the Department of Defense. And I don't know how the threats compare between the Department of Defense and how they compare to protecting the records and the privacy of our students. I do know that the Department of Defense can get as many as 1 million hits a day. And that is from, obviously, enemies around the world to some fifth grader sitting in a classroom somewhere, if you can believe it. My question is, obviously, from a military standpoint, we're working on this and doing everything we can to deal with it. From that standpoint, what is available, Mr. Couch, to right now that we can do to help you in education with this threat?
Well, one of the best things that is happening is if you bring people together, like of common states, so we deal with it as a team versus individually. So the CCSSO organization has been fantastic. I get to work with my peers, and we're sharing the information to try to deal with this on a large scale. And it's both. It's what are you doing structurally, as Dr. Lilly mentioned, because you have to have firewalls in place. There's a lot of technical things. But when you have the internal kind of vulnerabilities that we have, that's where the professional development has to really take place. And so you've heard us talk about our digital citizenship, trying to get that on the radar screen of our students and teachers so they become savvy and not taken advantage of, because a lot of this is taking advantage of people's good nature and trusting nature. And you don't want to make them totally untrusting, but there's a part, just like all the calls you get at your house, you go, I'm not sure that's really legitimate. And so there's a balance of that too. Having been a former Army officer, I'm familiar with those types of attacks, and also K-12, I find them very similar. The purpose is to be very disruptive or to gather information that can be used in a harmful way or for profit. So it's not been that big a leap going from one to this.
Well, thank you for your service, sir.
Yes, sir.
Yeah. Mr. Lilly, in your role, who is it that you seek, nationwide? Do you have a nationwide group that you work with to deal with this issue?
There are several national organizations that definitely provide guidance on student data protection and privacy. AASA is one that offers guidance to superintendents throughout the country. COSIN, the Consortium of School Networking, also is focused on this. So there are organizations, but I would suggest that this body may want to look to the states to see what protections they have put in place. I think that
on a state-by-state basis.
I think so. I think that that will give you a good overview of what's working and what's not working. And to some extent, I think that states and localities need flexibility in what works for them. There are a lot of different states in the country. So.
Well, the military, along with others who are fighting this battle, are constantly testing new ways to deal with it and are constantly measuring new threats that are out there. And somehow, from a collaborative standpoint, we kind of need to, because the business community, where I come from, we deal with the same thing. In fact, we produce legislation here to allow the business community to benefit somewhat from what we're doing at the Department of Defense and other areas of the federal government in what we're seeing out there and how we deal with these threats. So I think that some type of collaboration, where we can kind of let everybody know, okay, this is a new threat, this is how you deal with it. It seems like there's a new threat everywhere we look.
Just as a point, next week, the CCSO group, Council for Chief State School Officer IO Network, is meeting together, and we're focusing in on cybersecurity with all my peers across the United States. So it's
That's
us
great.
trying to.
Yeah, good. Well,
Thank
great.
you
I yield back.
very much. Ms. Bonamici, you're recognized for 5 minutes.
Thank you, Chair Fox, and thank you to the witnesses. I came to Congress with the goal of strengthening public education, and I visit schools on a regular basis out in my home state of Oregon. And as I visit those schools, I keep in mind the federal role in education about equity and opportunity, because that's where we make a big difference in making sure that our students in Oregon and across the country have equal opportunities. And I know data security and student privacy are important issues, but this is the 64th anniversary of Brown versus Board of Education, and Congress and this committee should be recommitting to that critical work of building on the progress that we've made. Chief Justice Warren, who led the court in that important decision declaring that separate is inherently unequal, wrote that education is perhaps the most important function of state and local governments. It is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. Such an opportunity where the state has undertaken to provide it is a right which must be made available to all on equal terms. I know, as Ms. Lehman is testifying, the Obama administration was promoting some systemic solutions to some of the problems, and we're making progress, for example, on segregation in our schools, improving equal access to educational resources, protecting transgender students, preventing campus sexual assault, ending discrimination in special education, and halting misguided school discipline policies that are fueling the school-to-prison pipeline. And unfortunately, that progress is under attack by Secretary DeVos and this administration. Rather than supporting our federal responsibility of advancing equity and protecting the rights of underserved students. So, Ms. Lehman, in that landmark decision, the Supreme Court did determine that separate educational settings are inherently unequal, and the result was, of course, desegregation of our schools. Although we've made progress in that goal, we have a very long way to go. In fact, in 2016, the GAO report, which you mentioned, noted a rise in racially and socioeconomically isolated schools. So addressing inequalities in schools, Ms. Lehman, was a priority for you during your time at the Office of Civil Rights. So would you please talk about some of the effective ways that we can and should be addressing the resegregation of schools today?
Thanks very much for that. The reality is that that is a crucial issue that persists today in ways that are enormously distressing. The data reflects that, and the education of our students reflects that in schools. I want to tell you about one resolution agreement that we had early in my time at the department. It was with an Alabama school district that had convinced a court that it achieved unitary status, meaning that it no longer offered segregated educational opportunity. That district had 23% black students, but in one of its 4 high schools, it was more than 90% black students at that school, begging the question about whether they offered integrated opportunity at that school alone. Then when we investigated, we learned that that school had never offered a single advanced placement course until 3 years before the investigation began. And when it offered it without a teacher. It was online only. The principal at that school said that the reason he wasn't offering high rigor courses to the students there was because those students needed remedial education. It's unbelievably devastating, low expectations for students in that school, coupled with their race. It was not the way that the other 3 high schools in the district were operating. The resolution agreement requires the district actually to offer high rigor courses to all students, and that's a key issue to make sure that we have high expectations, that we communicate to all of our students, and that we examine what kind of course offerings are available and who is prepared to teach them. Better than just saying that they'll offer that education, they went back to kindergarten to figure out what it takes to communicate to those students that the courses are for them and that the school would be ready for them.
That's good progress. And school climate and disciplinary actions, as you testified, can disproportionately affect students of color and students with disabilities. Some misguided conservative think tanks are trying to use some rhetoric and anecdotes to suggest that students of color and students with disabilities just act out more. Those claims do nothing to improve the educational experience for those students. We know that Secretary DeVos is leading the commission now examining school safety, and one of the key priorities of that commission is to roll back the entire Rethink Discipline package. Now that's goes farther and broader than the discipline guidance and includes seclusion and restraint, guidance, corporal punishment, dear colleague letter, guidance to provide a free appropriate education to students with disabilities, and guidance on school resource officers. So can you describe the goals behind Rethink Discipline and how the guidance has been helping to achieve equity and discipline practices?
Sure. The goal of the package was to make sure that we have our students in our classrooms learning appropriately and that we are ready for them. There's certainly the core component of non-discrimination, which was described in the guidance that I signed, but the other components of that guidance package also talked about ways to effectively teach students in school without having to resort to exclusionary school discipline, maintaining effective practices for classroom order, and making sure that our teachers and our students can do the work that they came to school to do, which is to learn.
Thank you. Madam Chair, I'd like to submit a letter to the record from the American Civil Liberties Union expressing the importance of Brown versus Board of Education, calling on Congress for oversight and signaling grave concerns about
Without
the rollback of
objection.
civil rights protections.
Without objection.
Thank you. I yield back.
Mr. Smucker, you're recognized for 5 minutes.
Thank you, Madam Chair. Dr. Lilly, you mentioned in your testimony that you had purchased cyber protection insurance, and I'd like to just hear a little bit more about that. There's some debate, at least among cybersecurity professionals, that having insurance could sort of adversely become an incentive for hackers to target, because they know there's a policyholder that could pay a fee. And so, were there any risks like that you considered when making a decision to purchase that insurance?
Thank you for the question. Our reasoning for purchasing the insurance was not to be able to pay ransomware or any of that, but really to have assistance should we have a breach. We are doing everything in our power to prevent a breach, but never say never. I mean, those things happen, of course. So with the policy that we have purchased, it provides a team to come in actually and work with us on incident response. Of course, obviously, we would notify parents of the breach, but also try to harden those systems. The insurance policy also helps us look at things, much like the product I discussed earlier, to help us think through the things we need to be doing to prevent a breach in the first place, including looking at what our third-party vendors are doing with data.
Sure. Did you find there were a lot of vendors offering insurance? And how difficult is it to price insurance like this?
Well, that's a good question. Our state school board organization, TSBA, Tennessee School Board Association, actually has a partnership with a company that offers that at a very reasonable price to districts, so we really didn't have to go out in the marketplace and look for it.
Oh, great, I see. And this question, I guess, for anyone, there's a lot of course, technology is changing on an ongoing basis. The risk changes, I'm sure. The risk is certainly increasing. What do we need to be thinking about in terms of ensuring that the framework that we put in place, the update we do, doesn't become outdated quickly? And particularly as we think about, there's going to be time involved with rulemaking, guidance, and so on as it gets disseminated down to the states. Is there something we should be thinking about in that regard?
So are you thinking about the update to FERPA?
Yes.
So I would say, without being too harsh, that FERPA mainly protects paper and traditional metal cabinets versus protecting students in modern digital times. And so previously, you could not roll up the data like you can today. And that's why you're seeing us put so much emphasis on, and you talk about security, one of the best ways to prevent having insurance is to really educate your staff. Like we have with our one-pager, we put it in human speak terms for our teacher, the digital driver's license. I think that is one of the best ways to address that. But FERPA in particular, we have got to get the vendors to sign off and be held accountable. They really haven't in the past, so that's probably the big part of that language that needs to be modernized.
I would also add, in order to keep up with technological development, ensuring that there is a broad structure, a minimum standard that can be built upon by the great state laws that have been passed over the past few years, written in plain language. Many of the issues that come up with FERPA are because you have to go back and forth between the statute and the regulations and guidance and apply it to situations that weren't imagined when the law initially passed. I
would agree with everything my colleagues have said up here. I would urge you to look to the states at what they need. One of the nice things about ESSA is it kind of provides what you said, the framework, and gives states and localities some flexibility, and I think that is important too.
And I just, if I could add, just not human speak for FERPA, but also the terms of services for vendors. Most of the time, it takes an hour to read those. If you have a hard-charging classroom teacher, they kind of go through it much like anything, say, accept. And so you got to really make it very succinct and make sure they understand what privacy is and is not in those terms of service.
All right. Thank you.
Thank you, Mr. Smucker. Excellent questions. Mr. Takano, you're recognized for 5 minutes.
Thank you, Madam Chair. Ms. Lehman, I'm going to begin with you. Thank you for being here, first of all, and I'm, as the co-chair of the Equality Caucus and as a former teacher, I appreciated the significance of the guidance that was issued by the Department of Education and the Department of Justice in May 2016 to inform schools of the civil rights of its transgender students and to ensure that they are provided a supportive and non-discriminatory school environment. The Dear Colleague letter outlined terminology and legal requirements under Title IX that prohibit sex discrimination, which included discrimination based on a student's gender identity. And that transgender students must be permitted to participate in sex-segregated activities and facilities such as bathrooms and locker rooms consistent with their gender identity. And as one of her first acts after taking office, Secretary DeVos rescinded the Dear Colleague letter on transgender students on February 22nd, 2017. She rescinded the guidance despite judicial rulings upholding Title IX doctrine and the letter itself. The Secretary did this without providing any direction to schools about how to now address issues that arise based on a student's gender identity. Schools are left without direction when it comes to preventing or addressing discrimination based on gender. Now, according to an organization known as GLSEN, 75% of transgender students report feeling unsafe at school. As a former teacher, this really, really concerns me. In fact, it's very upsetting. I always felt it was my duty as a teacher to create a safe space for my students. What effects will the Secretary's rescission have on schools and transgender students?
Thank you for the question. The rescission of the guidance sends a message to all schools in the country that they do not need to protect transgender students' equal access to educational opportunity, which is devastating. And worse than that, the department has now adopted a position that it just does not have jurisdiction over transgender students' access to bathrooms and locker rooms. Those students are required to be in school every day. They have to make a choice every day about which bathroom or which locker room to use. Not having guidance and not having protection of the federal government that is promised by Congress and has been promised by Congress since 1972 is devastating for those students and can have life-altering consequences for them.
Well, how does rescinding the department's transgender guidance serve schools or the students' best interests?
It has not served either school's best interest or students' best interest. We received many, many, many questions from schools themselves, from administrators, from principals, from teachers, from their associations, asking how it is that they could serve those students and how to make the decisions that they needed to make every day to satisfy those students' rights. Withdrawing the guidance means that they don't know the answer to that question, and that leaves that up to the vagaries of local state decision-making, which is dangerous for those students, in contrast to what Congress has promised.
Does the medical and scientific community recognize that transgender people exist and transgender is something that's real?
It does uniformly recognize it, and also recognizes the consequences to those people about not being respected for who they are.
How is it in accordance with the Office of Civil Rights mission to ensure equal access to education?
That is core to the department's mission. It's in fact the reason that the department exists. And so rescinding guidance and operating in ways that are contrary to that mission is contrary to Congress' charge to the department.
I mean, among the many conclusions I draw for this, I mean, the motives, I mean, I have to believe that the Secretary just doesn't believe that transgender students
exist and does not recognize the situation that they're in every single day. As you say, they have to make choices every single day about which bathroom to use, what activities they can participate in. And there's simply a non-recognition about the reality of these young people.
It's either a non-recognition of their reality or it's affirmatively turning it back on that reality. Either one is devastating.
Yeah, I am devastated on behalf of these students. I've personally have been in classrooms where transgender students are being bullied and picked on, and we need a better support system within the schools for educators and better support system for our administrators.
One of the first cases in which the department withdrew its support for transgender students was on behalf of a little girl who had to go to the bathroom every day at her school. The school lined up the students by girls versus boys, and she had to decide whether to out herself as transgender every day or line up in the line that was inconsistent with how she appeared to her peers, because the school did not want her to be able to be treated consistent with her gender identity. That student has attempted suicide because of the school's response to her. That's devastating to her as a human being. It's devastating to all the other students at the school, but the way that that student is treated, and it is reprehensible for an office that is charged with making sure that it secures equity for all people.
The gentleman's time has expired.
Thank you, Ms. Lehman.
Mr. Ferguson, you're recognized for 5 minutes.
Oh, Madam, may I submit a letter for the record?
Without objection.
Yes, thank you.
Thank you, Chairwoman, and thank you to each of the witnesses for coming today. Mr. Crouch, I want to follow up on something when you were discussing a question from Representative Smucker, and you said that the vendors have not been compliant or not been not been compliant with FERPA. Can you explain that a little bit more, clarify that for my understanding of what non-compliance is and why they're, and can you go into a little bit more of why they're not being compliant?
Well, I think it's more, they've not been held as accountable if they've been lackadaisical with the data they have been trusted with. And so FERPA needs to be strengthened because when it was created back in the 70s, you really didn't have a lot of vendor partners like we do now. And so it really needs to be strengthened. And most companies will take this pretty serious. They want to stay in that kind of business. But particularly your smaller ones may just be starting out, have not thought all the way through. So just like we talked about the signature requiring it, is they need to understand there's a serious consequence if they're lackadaisical with it, especially as you have changeover in people and it goes a period of time, you can lose track of it. So just putting some teeth to it.
So I have a healthcare background, private practice for 25 years. Our version of this is HIPAA.
Yes.
How do you see, or can you speak, any of y'all speak to how closely the regulations in HIPAA are lined up with FERPA? Is that a good model? Should we be thinking more in that term for privacy of data? Thoughts on that?
Well, I'm not a HIPAA expert. Only when I visit the doctor's office, I have to do certain things, so I'm not really sure how well they align, but there's a similar flavor to it. And just a consciousness, I think the intent of FERPA was good. It was to be conscious of the importance of privacy. It's just the problem that the law was written so long ago, it's not relevant in the digital world, it's not as relevant. And I suspect some of the older laws that were put in place, and HIPAA has the same kind of good intent, probably just needs to be modernized.
Okay. So we're sitting here listening to that, there's as someone that owned a healthcare practice, if I had a vendor that came in, we required them to do exactly what you're talking about, and I think that protects everybody.
But an important piece is, I don't want it to get lost, is this terms of service, because a lot of times it's written in legal speak, and the average person can't follow it. So I'm just as determined. There's a place I go to, it's Waffle House a lot, and I say, put things in Waffle House speak. If I can't go to the left and right of me and explain it, you've not done it well enough. And so I would say the terms of service need the same type of thing, for no matter the company, so the average person can follow it.
Well, who was it, Senator Kennedy from Louisiana, when he was discussing the fine print in the Facebook agreement, said it might as well have been written in Swahili?
It's right.
So I agree with you. Making it clean and simple, I think is important. There's in this topic, there's good, bad, and ugly. One of the things that I think it's, an example of what is working is in Georgia, and our State Department of Education has instituted sort of a longitudinal system that enables the teachers to, to track the students, get them lined up in the right programs. And also our university system is working with the reverse transfer. So there are and so we're awarding degrees to people that otherwise wouldn't have. So there's some really good things that can come out of that data. And to me, a great example is Georgia State University, where they're using predictive analytics to see where their students are going, and they've raised their graduation rate from 32% in 03 to now over 54% with that program. So while there's certainly some issues, we need to be very mindful of that. I think there's some great success stories out there too about how we can utilize data to help this, help our students succeed. So with that, I yield back and thank you.
Thank you very much, Mr. Ferguson. Mr. Espaillat, you're recognized for 5 minutes.
Thank you, Madam Chair, for this important effort to discuss privacy and keeping data safely, which is an important task. However, on this day in 1954, the Supreme Court ruled that separate meant unequal, ruling against the segregation for the first time since Reconstruction. After the Supreme Court's ruling in Brown versus the Board, Justice Thurgood Marshall, head of the NAACP's Legal Defense and Education Fund at the time, warned that the fight really had just begun. To this day, the fight continues to ensure that each and every student, regardless of race, color, ethnicity, sexual orientation, or socioeconomic background, has access to equal and equitable education opportunities. But even before that historic decision, Supreme Court decision, in fact, 7 years before, in Orange County, California, you had the Mendez versus Westminster decision, which addressed anti-immigrant feelings in that state and the so-called Mexican schools that were established to segregate Mexican students from white students. And that came as a result of a national anti-immigrant feeling very similar to what we're seeing today. In fact, just yesterday in New York City, we saw in social media how an attorney, Aaron Schlossberg, engaged in a xenophobic racist rant that went viral across social media, asking folks that worked in a restaurant near his office not to speak Spanish, that it was almost illegal not to speak Spanish. And so while I believe that protecting privacy and keeping data safe is critically important on this day, and given the administration's apparent lack of concern for civil rights, I would like to take this opportunity to talk about civil rights. And in 2014, Ms. Lamont, the Office of Civil Rights, under your direction, took action to clarify that all students have equal access to education resources. This requirement falls under Title VI of the Civil Rights Act. The guidance documents outline how OCR investigates resource disparity and what schools must do to meet their obligations to all students. Now, 4 years after that release, and 64 years after Brown versus the Board of Education, and 71 years after Mendez versus Westminster, we must continue to ensure that students have equitable access to educational resources. Now, I've been joined by a group of students who flew in from New York City. They are Lehman College students from the City University of New York. And I'm so glad that they're here on this day as we recognize Brown versus the Board of Education. But my question, Ms. Lehman, Ms. Lamont, is how does addressing access to education resources get us closest to achieving the goals of Brown versus the Board of Education?
Thank you. Communicating to students through equitable opportunities is the core function of schools, and we have not yet lived up to that core promise of Brown. We saw in the most recent data that's come from the Civil Rights Data Collection at the Department of Education that the opportunities available to students are profoundly inequitable. Just as one data point, that new data shows that only 58% of our nation's schools that offer 8th grade offer algebra to students. If students don't take and pass algebra in 8th grade, they will not be eligible for competitive higher educational opportunity. So that very low percentage of course offerings to those students is unbelievably distressing. And then when we look at the rate of course taking for African American students in 8th grade algebra and then course passage, it's well under proportional to their representation in the schools. And so we know, just on that data point alone, that we have profound inequities in the offerings available to students. That is exactly the kind of issue that the Brown versus Board of Education decision and the Mendez versus Westminster decision were designed to address, and all these years later, we still are well behind the kind of offering that we should have for our students in schools.
Finally, Secretary DeVos continues to signal her intent to walk back disparate impacts analysis and guidance documents related to Title VI regulation. Without this guidance, will schools have the resources they need to comply with the law?
Well, the guidance helps schools understand how to comply with the law, and that's a critical function. But the law itself mandates analysis of disparate impact still. So withdrawing the guidance will not take that away, because that is the law of the land today, and it has been the law of the land since the regulations were enacted.
Thank you, and thank you, Madam Chair, for the time.
Thank you, Mr. Espaillat. Mr. Wahlberg, you are recognized for 5 minutes.
Thank you, Madam Chairwoman. I'm going to go back to the topic of our hearing today, if that's okay. Ms. Vance and the rest of the panel, thank you for being here to talk about data and data security for our students. 3 years ago, the Electronic Frontier Foundation filed a complaint with the FTC alleging that Google for Education collected and used students' data for non-educational purposes. Among the concerns was that when students were logged into their Google for Education accounts, information on students' use of other Google services was collected and synced with the student data for non-educational uses. Is this a violation of the Student Privacy Pledge since it was done without seeking the permission of the students or their parents?
You'll have to forgive me because I was not at FPF at the time the letter was sent, but my understanding is that at that time, SIA and FPF reviewed Google's practices in line with the Student Privacy Pledge and found that it did not, in fact, violate the Student Privacy Pledge. In fact, the particular element that EFF was criticizing was crucial for schools to be able to use a single device for multiple students, allowing increased technological equity for many schools.
Does this seem like an appropriate use of data collected via educational offering to high school and elementary students, though?
I'm afraid I don't know enough about the specific data collected to answer the question. Sorry.
Anybody?
I will tell you that I'm a public school parent of 2 little girls, and I am very, very concerned about that kind of use of their data, and very, very concerned about that issue.
Yeah, I have grandkids. I'm very concerned about that as well. Mr. Couch.
Yes, sir. There's a balance. I think most of the companies are trying to improve their products, so that's the balance they say is take a look at the use. I think anything a student does in the creation and using those products is part of their educational record. And to me, as a parent of 4, and now a grandfather, is before that's released or sold, that needs to have the parent's permission. It kind of goes back to really the parent and the student owns the data. And before it moves on, it should have their authority before it moves on, even as it changes form over time as they're using the product.
Let me ask an additional question, Ms. Vance. What does the market for student-issued technology look like? And secondarily, does one company have an overwhelming presence in the market?
I do not know the answer to the first question. I'm afraid I'm a lawyer, so that's where my area of expertise lies. I know it is an extremely large market. We've had several companies enter the space over the past few years, many of them parents and former teachers who found there was something that students were not getting, such as additional services for autistic students, or something that helped improve the climate of classrooms. You have a few actors that are more predominant in schools, for example, G Suite for Education, which you mentioned, Class Dojo, I believe Microsoft Office, though that is primarily in higher education space as the primary leader there.
Is there a concern that these companies have the opportunity to track individual students and their interests from the time they're students on throughout their life?
One would certainly hope that they are not tracking for the rest of their life. As a provision of the Student Privacy Pledge, companies are not allowed to keep data any longer than the specified educational purpose unless they get consent from the parent or student.
The two superintendents, do you feel the same way?
Earlier, I mentioned that I think that it is worthwhile to see what protections are in place in the states. In 2016, Tennessee's General Assembly passed a Student Online Personal Protection Act, and they addressed some of the questions and concerns that you have. They prohibit third-party vendors from targeting advertising toward students, from creating profiles, and most importantly, from selling that information.
We had legislation passed in 2014 doing similar types of things, both the privacy and the cloud side of vendors.
To add to that, 20 states have passed legislation along those lines.
Thank you. I yield back.
Thank you very much. Ms. Davis, you're recognized for 5 minutes.
Thank you very much, Madam Chair, and thank you to all of you for being here. I know that the issue of exploring how our schools and our states can keep data safe is certainly a very important one. We all acknowledge that, but I think it's also very important, as my colleagues have stated very clearly today, that on this anniversary, 64th anniversary of Brown versus Board of Education, the basic keeping our students safe, embodied in our opportunities in this country to move forward with civil rights legislation, also needs to be recognized. And that's why I think we're wanting to be sure that these basic rights are addressed on this particular occasion. I also wanted to turn today to Title IX, because I think that so much that we talk about today is really embodied in Title IX. And young children today even know about Title IX. Certainly young women know about Title IX. And we always point to our Olympic winners and remind everyone that this was a long history. It didn't just happen. None of this just happens. And that's why it's so important to look at how we move forward. Moving forward isn't necessarily, just kind of letting things slide. It's not going, maybe a half a step forward and 3 steps back. I mean, that's what I think we're concerned about today. So let me just talk about, in 2011, the Department of Ed issued guidance explaining a school's responsibility to address the requirements of Title IX in instances of sexual violence. The Office of Civil Rights then released a document in 2014 clarifying the regulations. And Secretary DeVos, as I think we're all aware, rescinded both the 2011 Dear Colleague letter on sexual violence and the 2014 questions and answers on Title IX and sexual violence. So I have a letter here that was written together with Congresswoman Jackie Spear and 12 other colleagues who actually serve, 12 other colleagues and some of our colleagues who serve on this committee, to enter into the record, because the letter is important. It emphasizes our concerns about efforts from the DeVos administration to weaken Title IX protections for students. I also have a letter here from the National Women's Law Center that I would like to enter into the record, if I may do that, Madam Chair.
Without objection.
Thank you very much. Ms. Lehman, what effects do you think that this decision by Secretary DeVos has on schools? What effect has it had, and how will the decision impact students? What do they pick up from this?
Certainly, the decision to rescind critical non-discrimination guidance sends a strong message that discrimination is permissible. The guidance that the Secretary, the interim guidance that the Secretary has put in place to replace the guidance that she rescinded on this topic violates the law in multiple respects, and so it also sends a message that that compliance with the 46-year-old Title IX requirements is no longer essential and is no longer to be expected, will no longer be enforced. And so that's very dangerous. The message that it sends to our students is that they will be unsafe at school and that they do not have a right to expect non-discrimination on the basis of sex in school in a way that is retrograde and takes us back well before 1972 when Title IX passed.
Yeah, I'm wondering about schools too, because aren't they getting a lot of mixed messages right here?
They certainly are.
You know, they're being actually asked to pick their own evidentiary standard of review, as opposed to consistently applying the preponderance of evidence standard that is used in most civil cases. So how are they really looking at that?
Well, the schools are left without guidance. They're left rudderless in how it is that they can satisfy Congress' command to their students and how it is that they can protect their students. That renders the students dangerous in itself. It also leaves the schools to, they're bereft of the expertise that the Department of Education has amassed over the many years that it has been enforcing Title IX and the various fact patterns that the department has. And so the schools are left to try to educate students and also be civil rights experts at the same time, which is a lot to ask for a teacher or a school administrator not to have the benefit of federal guidance.
Yeah. Are you suggesting then that the guidance really has to be clear about what those expectations are? It's clear. It's really with the eye on the law, not just the, an individual response to the law.
I do think that the guidance needs to be very clear so that people understand how to use it and also how to apply it. I also think it needs to be consistent, and it needs to actually have absolute 100% fealty to what this body has said the law is and what the courts have said the law is, which is not what we are seeing today.
Do you think we're going to be seeing steps backward now as a result of that?
I am very, very worried that we will and we have begun to see steps backward.
Yeah. Thank you very much for your testimony. Thank you to all of you.
Thank you, Ms. Davis. Ms. Handel, you're recognized for 5 minutes.
Thank you, Madam Chairman, and to the panel, thank you for being here. I apologize, I was in another hearing and did not get to hear your testimony, but know that I read each and every one of your documents that were provided to us, so thank you. My question is for Mr. Couch and Dr. Lilly. And Mr. Couch, in your written testimony, you referenced some 4 billion unauthorized attempts to access data. That is a stunning number. Do you think that translates across to the other states as well?
Yes, it does, and those are the exterior attacks that we're seeing, like someone trying to open a window, coming through a door, and so we just saw those pushed away. One of the just as equal is our concerns of the phishing attacks.
Right.
And we're seeing an 85% increase in a very short period of time. That it didn't work on the technical side. So let me work on the non-technical side of trying to get this information. So we really feel like ours is 4 billion, but that's probably the same amount that's happening in other states across the country.
Good, and you referenced Dr. Lilly's reference to the phishing. So, and reading the testimony, again, this is for both of you, it's clear that we have a whole lot more work to do in all of this. It's not just modernizing FERPA, but I think there are a lot of other things for both student privacy and faculty and educator privacy. Can each of you give me just maybe 1 minute on what your specific thoughts are that we need to be focusing on in terms of priorities? Because it's a really big topic to tackle. Dr. Lilly and then Mr. Couch.
Well, thank you for asking about that. I think that our priorities need to be, much like Mr. Couch alluded to earlier, professional development. We have to make sure that everyone is aware of this issue and how important it is to have safeguards in place for student data and privacy. Also, there's more than one angle here. It's not only educating folks about it, but also protecting data through hardware. You know, when those people are making attacks on our systems, we have to have systems that can hopefully mitigate some of those. I know that the Title IV-A block grant gives districts flexibility because not everyone is the same. We're at different places of development in our infrastructure, but also in professional development. So to have that flexibility, I think, is imperative for districts and to have that funding. And we appreciate that this body has provided that funding. It is essential, really, to protect student data and privacy.
Thank you. Mr. Couch?
Yeah, there's we call cybersecurity and privacy. Those are related. They're separate, but they're kind of like close cousins. I think the most important part is folks got to be strategic about what data is collected. I talked about being on a healthy data diet. You challenge each other about, do you really need it? Do the districts see the added value of it? If they don't, and they don't use it daily, the quality of it's rolled up is bad, so why collect it anyway? So you got to spend a lot of time as a state working with your districts and with your schools on the value of it. But also I would say there's a balance when you're talking about with researchers. They're trying to do some good things with the information. And there's a tendency with researchers, I want it all, and I'll figure out later what I want. And from a school district perspective, that really puts a burden on them. Sure. And so that's why there's even a challenge for researchers over a period of time is be very strategic and focused about what you need over the course of time. And I would say this in regards to any kind of security, there's a balance between being secure and making it operational so people want to use it. Because if you make it too constrained, they will just go around it. So there's always that balance.
Great, thank you. One last question before my time is up. Mr. Couch, how do you make sure that parents understand exactly what you're doing in data collection and what you're doing with that data? And then secondly, how does your school system work with students to ensure that they are aware around data collection and what might be happening in their interactions on social media?
Well, let's start first of all with FERPA, the directory, the basic information. We have parents sign that. That's what districts are supposed to do. And just to remind parents, you're the owners of the data, and the rest of us are just stewards of that. We are also the first state to create a student and parent portal of their information. We notice a lot of school report card systems are trying to do that around the country now, but that lets the parents see the added value of that data to them and their daily environment. As my children started getting older, especially in high school, they weren't running to me and say, hey, Dad, this is what I'm doing. Third grade they did. When they got older, they didn't. So it allowed me as a parent to have a discussion with them as they got older. So I think the part is we always have to do with these systems is show the added value to the parent, but also there's some other added values to the district in collecting that.
Thank you. My time has expired. Thank you, Madam Chairman. I yield back.
Dr. Adams, you're recognized for 5 minutes.
Thank you, Madam Chair, and for convening this hearing, and to the individuals here testifying, thank you very much. I do want to applaud my colleagues who recognizing the anniversary of Brown versus the Board of Education today by focusing on the assault that the Department of Education is waging on our collegiate women, LGBTQ community, and students of color. And with that being the case, Chairwoman Fox, I want to submit for the record a letter from the Disability Rights
Without
Education.
objection.
Thank you very much. Ms. Lehman, the Office of Civil Rights oversees the department's enforcement of Title VI of the Civil Rights Act. The regulations in Section 100.3b2 prohibits utilizing criteria or methods of administration which have the effect of subjecting individuals to discrimination based on their race, color, or national origin. This element of the regulation allows for analysis by OCR to determine if a policy or practice that may not be adopted with the intent to discriminate is in fact having the effect of discriminating. Can you elaborate on how disparate impact analysis applies in education, and does the presence of disparate impact necessarily constitute a Title VI violation?
Thank you. The presence of an unlawful disparate impact does necessarily constitute a Title VI violation, but there are multiple steps to determine whether the disparate impact is in fact unlawful. The regulatory requirement, which has been operational since the beginning of the department's regulations of Title VI, is that the department examine both intentional discrimination and an unjustified disparate impact. The disparate impact would be that a neutral policy or practice has a disparate impact. It applies more to one racial group than to another. And then the question for the department is whether, if that happens, if there is an educational justification that merits that disparity, and if so, is that educational justification necessary to the educational enterprise? All of those steps have to be investigated before the department determines that a disparate impact is unjustified and unlawful. But it is also not an open question whether the department may or should use the disparate impact analysis. It is a regulatory requirement. It is part of the existing Department of Justice Title VI legal manual today in this administration and in prior administrations going back many years. So that is an essential core component of the work that the Department of Education performs when it is examining race discrimination in schools.
Okay, so what are the repercussions then if the Trump administration acts to rescind or remove the disparate impact analysis from the discipline guidance?
Well, the repercussions would be to send a misleading and false message to the full educational community because the regulatory requirement would still exist. So removing it from the guidance does not remove it from the law. The law is that the department must investigate it. The law is that our students in school are entitled to assurance that they will not be subject to an unjustified disparate impact. And so removing it from guidance would remove it from the educational community's core understanding about how to satisfy the law and student community's core understanding about what the law is, but it doesn't remove it from the actual right that the students have to non-discrimination in school.
Thank you. To add to my concerns, Secretary DeVos has been, in my opinion, derelict in her duty to approve equitable state plans under the Every Student Succeeds Act. Section 3C4C says that each state shall establish a system of meaningfully differentiating on an annual basis all public schools in the state, which shall be based on all indicators in the state's accountability system. And I want to reiterate there, for all students and for each subgroup of students. Unfortunately, though, many states have submitted plans that ignore subgroup performance entirely, and the Secretary has approved these plans as compliant. In your legal opinion, would you say a state complies with these requirements if it proposes to develop a system of annual meaningful differentiation that is solely based on all student groups and does not include the performance of subgroups?
The short answer, Congresswoman, is no. If a state ignores the law from Congress, the state violates the law, period. And what you're describing violates the law.
All right, thank you very much. Madam Chair, I yield back.
Thank you. Mr. Banks, you're recognized for 5 minutes.
Thank you, Madam Chairwoman. And first and foremost, to you and the ranking member, I am so excited and honored to be here to be a part of this committee. I intend to be a very productive member of this committee, as everything that is dealt with here is important to each and every one of my constituents. And thank you to each of our guests here today. This is an important topic. My first question, though, is somewhat of a philosophical question for each of you that deserves just a brief answer. Would you agree that school administrators have an obligation to understand the privacy implications of technology? Mr. Couch?
Oh, absolutely. And that's why we spend so much time trying to educate them, but also their responsibility to mentor others within their organization.
I would echo Mr. Couch's response.
Without question, I agree.
Absolutely.
Okay, thank you. Ms. Vance, as a follow-up to that, I wonder if you could elaborate more on whether or not you really believe at the end of the day that the school privacy pledge has actually worked. And then maybe to elaborate after that, where has it fallen short?
Absolutely. So I do think it has worked. The original goal back in 2014 was to make sure that there were clear commitments and clearly stated in plain English about what companies would and would not do with student data. And the almost 350 companies that have signed on so far are giving a sign to districts that they care about privacy and that they commit to fulfilling those promises. I always say when I talk with districts and states, though, that the pledge is an initial step. It is a sign. It was never meant to be all-encompassing and hit upon all of the many ways that companies have to step up and lead in this area. While the smaller startups may have less capacity, they certainly often have more capacity than most districts, where the IT director can be a gym instructor and the history teacher. And it's incumbent on companies to step up and have transparent policies, excellent security, and remember at the end of the day that they are stewards of that student data and should work in partnership with the districts that have entrusted it to them.
So as a follow-up, what's your advice to us? Where is the pledge most lacking? I mean, what can we do to strengthen the pledge and make it more effective?
I think at the end of the day, building upon the great work from state laws that really in some ways, I don't quite know the timelines, right before or right after the Student Privacy Pledge, the Student Online Privacy Protection Act was passed in California. That legislation, with some slight tweaks as it made its way from state to state, is now in 20 different states. And it builds upon the original foundation of the pledge to say this is how we operationalize it. This is how we add written agreements, how we add accountability, how we ensure that companies are living up to those obligations. So I would absolutely encourage that the committee take a close look at laws like Georgia's, Texas, Hawaii, California's, that have done that great work and really figured out both where the best practices are, as well as some of the unintended consequences that can occur in student privacy legislation.
Okay, that's very helpful. Thank you to each and every one of you. I yield back.
Thank you, Mr. Banks. Dr. Rowe, you're recognized for 5 minutes.
Thank you, Dr. Fox. And I apologize for being late. Dr. Fox and I are on a pension committee together on the Senate side, and I attended it, and I'll have to say she didn't miss much today on my. And I want to welcome Dr. Lilly, my friend from Bristol, Tennessee, and Mr. Vance, thank you for your service to our military. Thank you very much for that. I want to just start with Dr. Lilly just a minute. And you said in your testimony that funding through the ESEA block grant was important to you, to help you, as you work to protect student privacy. Can you tell us how you see these funds helping your district specifically?
Yes, thank you, Dr. Rowe. The nice thing about the Title IV-A block grant is that it does provide flexibility so that districts can use those funds for what they need. I think there are multiple needs for those funds. It's imperative that we harden our data systems to make them much harder to attack. So that is certainly one use of the funds, but also to address professional development so that we are continually keeping this issue front and foremost in the minds of our educators and our students.
And another question just occurred to me when I was listening to the testimony, is when you have a child in school that there may be disputed custody on the child, and how do you know which parent has a right to that information, or do they both, or do you have to go to a court to figure that out?
So it's one of the interesting quirks of FERPA. The court actually has to rule that a parent does not have the right to that file. Even if a parent loses custody of that child, they still are able to access the child's information. I would add, this is perhaps one of the strongest reasons dealing with these types of family custodial situations, why it is best to give parents access to their child's record through schools that are aware of these situations and can make these decisions, as opposed to having parents go to companies who would then have to collect information on sensitive family situations, as well as figuring out who parents are and some sort of authentication method.
Well, that's what I was wondering, because you might come in and say, well, I'm the child's father, or whatever, and I'd like to see what the grades are. They live with their mother. How do you deal with that? What identifier do they have to come in to do that?
Perhaps Dr. Lilly can speak from the perspective of districts on this. Usually the school has information, robust information on who the parents are, and can provide that information.
That is correct. We do collect a lot of information about our students and their parents, and we strictly go by the court orders that we receive to know whether or not a particular parent should have access to those student records.
What kind of, Dr. Lilly, what kind of costs are you incurring to put because it's amazing to me. I'll tell the story, it's hard for me to believe I did this, but I hung my honorable discharge to the Army in my office. And I didn't realize it, 20 years later, 25 years later, I'm talking to a patient and their husband about the surgery they're going to have. And I left the room and came back, and the guy said, "Doc, you should take your honorable discharge down." And I said, "Why?" He said, "Your Social Security number's been up there." It was hanging in wide open public for 25 years, and nothing ever happened. And now we're spending tons of money. So what kind of money do you spend to help protect that privacy where you are? And this is just one school system.
Well, unfortunately, I can't give you a specific dollar amount, but it is considerable if you do it right, and we have to do it right. So we're spending a lot of money to protect our data systems, but also for professional development. We have quarterly meetings where we look at what do we need to do next, where do we fall short. For example, you're talking about Social Security numbers. For years, that's how students were tracked, and a lot of places still do track by Social Security number. In Tennessee, there is a unique identification that can be assigned to students. We actually ask for the last four of a social because it's important to keep the students straight. But if districts send records of a student, often those records will contain Social Security numbers. And in our data system, we black those out. Even I can't access those. They are very guarded. But you have to be vigilant, which means you have to have personnel dedicated to this, you have to have systems dedicated to this, and you have to do professional development, and all of that costs money.
So it's a significant cost,
Yes, sir.
even for, and especially for our local school systems. They're fighting for every dollar they can
That's
to put in
correct.
student. Okay, I yield back.
Thank you, Dr. Rowe. Mr. DeSagne, you're recognized for 5 minutes.
Thank you, Madam Chair, and I may be unique in this perspective, but I found this discussion to be really interesting. I know it's disconcerting, given, and I think it's important to the chair and to the majority party that we talk about these issues, but I think it's equally important, and it may not be in the complete context both of us want it to be, but what the minority party has talked about. And for me, both of these things come into some confluence in the Supreme Court and two amazing decisions. To think of all those years ago that across the street, Thurgood Marshall was sitting waiting to hear what the opinion was, fully expecting a split decision, and then coming from California when I was in the legislature, I used to love to take young people out and look at Governor Warren's portrait and tell him the story of Brown versus the Board of Education from the perspective of Thurgood Marshall, when fully expecting to have the decision read and then have the Chief Justice say, so say, and identify what the split decision was, and ending in that wonderful, as it's transcribed in history, where he ended it by saying, so say we all, whereupon Thurgood Marshall looked at a couple of the members who had their own unique history when it came to, choosing my words here, segregation, and one of them was crying. In that wonderful, wonderful moment, and they said, of course, that the two key expressions being, in the United States of America, separate can never be equal, and then with all deliberate speed that we've struggled with ever since. And the context of the other perspective is when Louis Brandeis wrote that when it came to privacy, Americans deserve the right to be left alone. So here we are in the House of Representatives talking about two very separate issues, but I think potentially two issues that can converge in a moment of history. How coming from the San Francisco Bay Area and seeing both the success of data in our lives and also the dangers of data and privacy and misuse in our lives that we're talking about now. So first to Ms. Lehman, where do you see this convergence where we can see that in my district in the East Bay, which is a very diverse district, I've been in elected office for almost 30 years. When we look at disadvantaged school districts and schools, and I've been to every school district and almost every school in my district over the years, and performance, the data will almost exactly track over those 30 years, socioeconomic impacts and outcomes. We don't see people in California. There's a big battle right now in statewide elections for the governor and the superintendent of public instruction between the public school teachers and charter schools. It's been going on for years, but it seems to really come to a point. So being someone who believes charter schools can work in some circumstances when the community wants them and embraces them, but also seen them not work, particularly in disadvantaged communities in West County Unified District in the areas of Richmond, California, which is a very disadvantaged community in the Bay Area. But I don't see people going to other communities in my district or in the Bay Area, in wealthy communities that are doing quite well and equivalent to private schools. So my question is, how do we use data, as you see it, to actually embrace this period of history as opposed to maybe setting it back, so that we can actually get the desire that the Supreme Court wanted when they said separate can never be equal in the United States of America when it comes to education in particular?
I strongly believe that the data always drives equity. We need to know how our students are doing and how each of the categories that students fall into is doing, and that is one way to assess what is needed and also how to respond to it. There's also tremendous overlap with the data privacy concerns and with civil rights across all dimensions of the civil rights questions. In the transgender guidance that I signed, we had a component specific to FERPA because of the many issues related to which pronouns should be used, which names should be used for students who have transitioned, and at what point that set of changes should be recognized. We also saw tremendous overlap with respect to students with disabilities and with respect to sexual violence in schools about how much information should be given to whom and how it can be collected and how it can be acted on. So there are very many ways that the issue of student privacy overlaps with core civil rights issues, and we cannot move forward without effective data.
Anyone else in the 30 seconds I have left?
I would just quickly add that I mentioned many parents have privacy and security concerns, and one of those is around discipline records because of disparities, that information could then follow their children and perhaps disadvantage them in the future. So I definitely think the issues do overlap, and it's essential to make sure all information is protected. So that is not a fear that parents have to have.
Well said. Right at the end of my time, I yield back the balance.
Thank you, Mr. DeSagne. Ms. Bonamici, you're recognized for close. Oh, let me thank again our witnesses for taking the time to come before the committee and recognize Ms. Bonamici for closing comments.
Thank you very much, Chair Fox, and thank you again to all the witnesses who are here today and all the members who participated in this conversation today. I want to start by adding to the record 3 letters that all express the importance of the Brown versus Board of Education. Yeah, Leadership Conference.
Objection.
Thank you, Madam Chair. The Leadership Conference on Civil and Human Rights, the National Disability Rights Network, and the Council of Parent Attorneys and Advocates all call on Congress for oversight and signal concerns about the rollback of civil rights protections. Madam Chair and everyone here today, it's really important to note that student data is directly connected to advancing equity in education. Data is critically important to producing the answers we need to improve practice and results and to dismantle the disparities in our education systems. Just recently, within the last couple of days, we're reading a story about my home state of Oregon, where in a rural high school, LGBTQ students were harassed and bullied and forced by the school to read the Bible. That is unacceptable in 2018 that these students are being harassed. I would expect the Department of Education to be right there on their behalf. As we heard today, the Department of Education's civil rights data collection is essential to addressing these key issues on education and civil rights. And as we continue these efforts and reflect on this anniversary, let us remember the federal role in enforcing civil rights laws and truly fulfilling the equity required by Brown. This committee must choose the better part of history and reaffirm our commitment by holding this administration accountable and fiercely fighting to protect the rights of all students in public schools and on college campuses. Our nation's students are depending on us for leadership. Thank you again to our witnesses and members for attending today's hearing, and I yield back.
Thank you, Ms. Bonamici. Again, I thank our members and the witnesses for coming here today and discussing this important topic. As we heard, privacy is a very real, very costly issue for schools and states, and is an issue we must focus on. The witnesses described some great best practices to help protect student privacy and also recognize the need for us to update the law to help them do their job. I look forward to continuing the conversation and working with my colleagues on this critical issue. There being no further business, the committee stands adjourned.